me. If attorneys can please identify themselves and their readiness to proceed.
Good morning, Your Honors. This is Tom Bruns. I represent the appellants and I'm ready to proceed.
Good morning.
Good morning, Your Honors. Todd Marty on behalf of the appellees, and I'm ready to proceed.
Okay, thank you. Good morning. Attorney Bruns, would you like to reserve time?
I would. Thank you for asking. 4 minutes, please.
4 minutes. All right. Whenever you are ready.
Thank you. Your Honors, this lawsuit is actually rather straightforward. I know the briefs might throw you off because the briefs are quite lengthy, and frankly, I think the briefs are very well done in terms of analyzing and disposing of the issues. But ultimately, this case is exceedingly simple, and I'm here and my clients are here because the simple fact of a familial relationship among my clients, a wife, a husband, and her daughter who all worked for a charter school and provided services to a charter school. And the other fact that is essential to the trial court's determination was that the CEED, C-E-E-D, the janitorial company that Clyde Lee, my client, owned, VLT was its only customer. There are no more facts than that in this case. So let me just give you a quick background. VLT operated for more than 10 years. It was a charter school. VLT was audited by the Ohio auditor every single year. And at no point, and this is critical, at no point did the Ohio auditor ever make a finding for recovery, as it was statutorily required to do if, in fact, it found any illegality, including any illegal contracts or void contracts.
Didn't the auditor also miss like ECOT as well? I mean, I guess I don't know that the fact that they didn't perceive a problem is necessarily dispositive here.
Well, I would suggest, it's a good question, Your Honor. I would suggest that the auditor had every right to issue a corrected or revised audit report. Okay, just because the auditor makes a mistake doesn't mean the auditor gets to dispense with the statutory framework that the General Assembly provided for the regulation of charter schools. They don't get to go outside that regulation. So the auditor of state could have issued a corrected or revised finding for a report and then issued a finding for recovery. It never did. It is undisputed. The auditor never did that. Instead, what the auditor did was bypass the entire finding for recovery process by issuing a letter. And to kind of bring home how illegitimate that process was, this case took a contorted procedural posture. Your Honor, Judge Zayas, you read how the caption is son learning, right? Or son building or whatever. That was the landlord for my client, okay? This case started out as a lawsuit to recover back rent. And then the ODE moved to intervene. And then the ODE filed an amended complaint. And the Ohio Attorney General magically appeared as a party in this case without ever seeking leave, without ever amending, just or filing a motion to intervene. They just were in the case. And they asserted a bunch of different theories. And it wasn't until several amended pleadings that they hit on the argument that they essentially succeeded in convincing the trial court of, which is that the Ohio Attorney General always had authority under Revised Code 117.42. It always had authority to bring suit in its own name to enforce general.
Counsel, in looking at the statute, though, there's no limiting language in 117.42, and there's nothing in 117.28 or 30 that says that that's the exclusive remedy.
Sure, and I guess that's a good question as well, Your Honor. And I would suggest that there's a good response to that, which is simply this. This case presents a textbook example of statutory construction. All right, and thankfully this court has guidance because the Ohio Supreme Court has made it clear two things: statutes that are passed at or near the same time must be read in pari materia. Meaning you cannot read one section of the statute to make another section superfluous, all right? So if the Attorney General's argument is correct, then all the legislature ever had to do was pass 117.42. It didn't need to do anything else because the Attorney General just has this get out of jail free card, it can exercise its authority any way it wants, anytime
But I mean, is there a real inconsistency there? I mean, I think that the other statutes are more tailored to specific situations. What is the problem with giving, under their theory, giving the AG specific authority in particular circumstances, but also giving broad authority to cover other situations?
Because the Ohio Supreme Court disagrees with them. So the Ohio Supreme Court in Black Fork Wind Energy, one of the cases we cited, says, in all cases of doubt about the authority of a state agency, the doubt should be resolved against any grant of authority. So we don't read a statute, particularly a statute that has been passed with other statutes. We don't read the general to trump the specific. Again, if that occurred, if the general here, 117.42, trumped the specific, which is the finding for recovery process and the authority to then sue on that, if the general trumped the specific, then there's no reason for the legislature to waste its breath and put the language in 117.28, 117.30, and give the attorney general authority. It already had it. And not surprisingly, the only court to directly address this issue, the Henry Scott decision, disagrees with the attorney general. The attorney general has never successfully made this argument in any court until this trial court. Has never won this argument. They've tried. Henry Scott was a bankruptcy decision, but these issues were simply litigated in bankruptcy court as opposed to common pleas. And in that case, the attorney general made two arguments. They said, we're entitled to judgment as to the amounts that are covered by a finding for recovery. But then, as to amounts not covered by a finding for recovery, we're entitled to judgment as a matter of law under 117.42. And the court said, absolutely not. And I would like to point out in the briefs, the state has misconstrued the facts and the ruling in Henry Scott and has suggested that they didn't get judgment on the amounts that weren't covered by a finding for recovery because of some proof problem. That's not the case. The court rejected their argument as a matter of law. And the point being is that under 117.28 and 117.30 in the finding for recovery process, once the auditor certifies it and the attorney general sues on it, it is a prima facie case for recovery. They don't add any proof. They don't bring in any other theory. And so this idea that the attorney general has common law theory or strict liability, theories to go after, that's not the case. Henry, or the New Choices case out of the 2nd District, rejects the attorney general's attempt to expand its authority to regulate charter schools. Charter schools are a creature of statute under 3314. They are only to be regulated as provided for in the statute. And the attorney general doesn't get to expand its authority to regulate charter schools. And I'm not saying this, the legislature is saying this, and all the cases that have interpreted these statutes are saying this. So the attorney general does not have a single case that supports the theory it successfully argued in front of this trial judge. Henry Scott is dispositive. We also cite to the court the decision out of the 9th District, which is Police and Firemen's Disability and Pension Fund versus Akron. That is a 9th District case. And I'm quoting from that decision. The auditor of state determines in the first instance whether an illegal expenditure has occurred after the facts and circumstances of the expenditure have been fully and thoroughly investigated. The auditor does that through audits. In this case, the auditor had almost 10 years of audits and never, ever made a finding for recovery. And it always knew of the familial relationship between my clients. And by the way, all these contracts were voted on by an independent board who was represented by independent counsel, which an independent counsel was Phyllis Brown. And I don't think there's anyone in town who knows more about school law than Phyllis Brown. And she represented the board. And so there's no question that, and I'm quoting again from the Police and Firemen's Disability Pension Fund case, the plain language of the statute dictates that before a civil action may be instituted under this provision for the recovery of funds, the report must set forth that public money has been illegally expended. The auditor had 10 years of opportunity to do that. It did not make that determination. And why? the only fact anyone has ever cited is that these people are related. There is no evidence in this case that the contracts were above market. I know the state made that argument in its brief, but if you check those sites and you go to those sites, that's not what they say. And we clarified that in our reply. So there's no evidence that my clients didn't give value. There's no evidence my clients didn't perform their contracts. What we are left with is the mere family relationship among these parties. And so that is
in a charter school that collapsed, right?
And the reason it collapsed is because the sponsor, and this is a stipulated fact, the sponsor withdrew its sponsorship. And so you cannot have a charter school in Ohio unless you have a willing sponsor. Okay, and that's the only fact before the court, that the sponsor withdrew its sponsorship. That's it.
Thank you, Attorney Bruns. Unless there's any other questions from the panel, I will reserve you 4 minutes. Thank you. Attorney Marty, good morning again.
Yes, good morning, Your Honors. The facts of this case are undisputed and they're very troubling. The Lees purported to establish a charter school to help the disadvantaged children in the Over the Rhine neighborhood. But instead, they helped themselves to almost $2 million of the money from that school. It ended up in Mrs. Lee's bank accounts, either through contracts with her husband's company or employees depositing paychecks in her bank account. The trial court did an extraordinarily thorough job of analyzing that and explaining why it violated the public contract laws, fiduciary principles, and the civil RICO laws. The Lees don't have much to say about that or the underlying contract, but instead put their emphasis behind this proposition that without a 117.28 audit finding, it just doesn't matter. They claim that deprives the state of standing. They claim that absolves them of liability under the statutes the trial court relied on. But if you look at 117.28, it simply can't bear the weight that they put on it. Let's turn first to the question of standing. The common law gives the Attorney General authority to sue to recover public funds to protect public property. Although, and the trial court found that the funds that are at issue here are public property, and Lees have not disputed that on appeal. I'd refer the court to, I apologize, I don't have that in front of me. But in any event, although that common law authority can be restricted, the decisions require a very explicit restriction. The Supreme Court says that the language must.
So is the statute then totally superfluous because you have broad common law standing?
The statute reinforces the Attorney General's authority in one area, but the cases are very clear that reinforcement in one area does not restrict common law authority in the other. It's not an implicit restriction. And that's consistent with the idea that you need an explicit restriction. We see that again from the Supreme Court in Marshall and Merrill. So if you look at 117.28, it nowhere purports to restrict the Attorney General's common law authority. And indeed, the 6th District has already resolved this question. In the Johnson case, pretty much on all fours here, the Attorney General sued to collect money owed a public body that wasn't covered by a finding for recovery. The defendant, like the Lees, said, well, no finding, no claim, no standing, I should say. The 6th District said, no, the Attorney General has common law authority to collect public funds, regardless of whether there's a finding for recovery. There's no precedent to the contrary. Scott does not refer to that. It is not precedent to the contrary because Scott dealt with liability, not standing.
Well, one of the arguments this morning is that the charter schools is a creature of statute and can only be regulated by statute.
Okay, let me address that on several levels, Your Honor. First of all, we are not suing a charter school. We're not purporting to regulate a charter school. We're suing individuals who purloin funds from the school. But with regard to the Attorney General needing statutory authority to bring a case, I would highlight the distinction that the Attorney General is not a state agency. It's not a statutorily created agency. It's a constitutional office with its own inherent common law authority. And as mentioned before, the cases require explicit statutory language that limits that authority, and it's simply not there in 117.28. Furthermore, it's reinforced in 117.42. That statute authorizes the kind of claims we pressed here. If the auditor asks us to press them, no one disputes that the auditor did. That statute is nowhere conditioned upon a 117.28 finding. And there's nothing in 117.28 that restricts 117.42. So we would think that both there's no restriction and there's sort of a belt and suspenders approach here to the Attorney General's authority. And furthermore, something else.
Let me ask you this. They make the point that, look, all of this was disclosed to the board. They had counsel involved. And even if you ultimately conclude that, you know, what they did was wrong and maybe funds should be recovered, how do we get from there to like a RICO conspiracy?
Well, a RICO conspiracy is based upon multiple statutory violations. The contracts violated 2921.42. That's one of the predicate acts that will support a RICO statute. There were 6 separate contracts, have separate time periods, separate votes by the board. There were actually separate bidding exercises with separate alternate bidders involved. So you have multiple violations of one of the statutes that provides a predicate act. That creates the RICO statute, the claim.
Can you, on that same topic, I'm struggling with enterprise. So VLT itself, how could that be an enterprise? Because the purpose of the statute was to punish the enterprise, and that's not what you're doing here.
Well, the enterprise comes in 2 ways. It protects the enterprise by protecting it against corrupt activity, and that's what's happening here. The statutes expressly make either a corporation, a government agency, or a legal entity as an enterprise. That's 23.31C. The parties have stipulated that VLT was a community school. That makes it a corporation, that makes it a government agency, and that makes it a legal entity. That makes it an enterprise. So that is sufficient to.
But usually when you think of enterprise and think of a drug conspiracy, the enterprise is helping further the ends of the actors who are part of that conspiracy. The enterprise is not itself being taken advantage of, and I think that's a key distinction between the facts of this case and how I normally think of a RICO conspiracy.
Well, and I think there's a distinction in the law on that as well, Your Honor. There are 2 types of enterprises under the RICO statutes. There are enterprises, in fact, where people cooperate. They're not a formal entity, but they cooperate in a criminal enterprise. And then there are enterprises that are simply identified by statute as being an enterprise. You don't need both, you only need one. VLT fell within the statutory definition of an enterprise, and I think that's sufficient under the statutes to satisfy the RICO statute. And again,
well, but does that mean that anytime you have a bad actor, and that bad actor is employed by a corporation, that you transform the claim into a RICO claim?
No.
I think that's what I'm a little bit concerned about here, is the potential breadth of the theory.
Let me try and address that, Your Honor. What we're saying is, we're not saying that every time there's a corporation and a bad act, there's a RICO claim. What we are saying is when there's an enterprise that is affected by the bad act, who's injured by the bad act, then there's a sufficient enterprise to support the claim. So in other words, the enterprise is relevant here because it's the victim, not the perpetrator. Now, they perpetrated the bad acts in connection with the enterprise and against.
Well, but I guess I'm having trouble seeing how that's a limiting principle, because what if the evidence showed that VLT got some kickback here and it inured to its benefit? I mean, you'd still say that was a RICO enterprise, wouldn't you?
Well, that's not this case, and that's not the claim we made. Our claim is distinct. It is that VLT was injured, not that it was benefited. So it's the enterprise as defined by statute. It suffered the injury and therefore has the ability to make the claim. The injury, the bad conduct occurred independent of, I shouldn't say independent. The Lees did that on their own. It injured the enterprise of VLT. I'm not sure, have I addressed your question?
You have, thank you.
Okay. So let me return back to 117.28. That statute does not absolve the Lees of liability in substantive terms. That statute does not purport to be an exclusive remedy for the recovery of public funds, and that's important because the legislature knows how to do so, as highlighted by the cases we cite at page 18 and 19 of our brief. Furthermore, every Ohio appellate court that has considered the issue has held that 117.28 is not the exclusive remedy to recover public funds. There is no Ohio precedent to the contrary. The Scott case, first of all, is federal and not binding in a trial level case. Furthermore, it did not hold that as a matter of law. It held that as a matter of the record of that case. I know because I lost that case. We tried to make our case exclusively based on the audit report, and the audit report wasn't good enough for the trial court because it was a regular finding rather than an FFR. In this case, the VLT case, we made our case based on independent evidence outside the trial court. And there's been no attack on that evidence, and it was sufficient to establish the elements of the claims we relied upon. Indeed, there's not much argument in these briefs contesting the claims on the merits. It's all these prophylactic arguments about whether we can get to the merits. And 117.28 simply doesn't prevent getting to the merits.
Counsel, I have a question about the claim that the seed contracts violated 29-2142.
Mhm.
So the exception in 29-2142 C3, your argument is because there were no other clients or customers that they did not fall into this exception.
Mhm.
So if that is a requirement, are we saying that even if a company doesn't have the capacity to have more clients or customers, they need to get more customers or clients just simply to fall into this exception?
What I'm saying is, Your Honor, there are at least two reasons, probably actually three reasons, why we have to enforce that statute the way it's written. First of all, the preamble to subsection C says you've got to prove all the elements, and that is one of the enumerated elements. So the legislature has told us that. Secondly, there are practical reasons for that. If we read that statute, that provision out of the statute simply because one official can't make it, we increase the risk to the public significantly, because what it would mean is you'd have a situation where the statute didn't apply when the public official's company is utterly dependent upon the public office for its existence. The temptation is higher for abuse there than it would be in pretty much any other situation. So I think it's wise to require that benchmark so we can measure it. If they can't make the benchmark, maybe they ought to find other people to do business with instead of the public office.
Well, but what if you're in a rural county and you just don't have a whole lot of options, and you do have this entity that's available on these facts, and you go to the board and you say, look, we don't have anyone else to do business with. We got to do this. The contract is fair. Look at the terms. What do you do in those circumstances?
Well, I guess I'd respond in several ways, Your Honor. First of all, the legislature said what the legislature said, and it says all these elements must be proven. Secondly, that's not this case. In fact, the bids in this case, which you can find at pages 247 and 297 of the joint stipulation, show that there were multiple other bidders, and in fact, they all came in lower than Seed did. And finally, there are a solid body of precedent out there saying that this exception is to be construed strongly against the public official, the party that seeks to bring it in. We see that in multiple ethics commission decisions. Furthermore, this codifies the common law rule that a fiduciary who seeks to, it creates an exception to the common law rule that a fiduciary who seeks to do business with his beneficiary must prove that the deal's on the up and up. That's an exception. So exceptions should be narrowly construed, particularly in this context. And finally, this is a statute that protects public funds. And the cases are clear that those kind of statutes, doubts need to be resolved in favor of the public. So you add the fact that you have an express statutory command that all these elements must be proven. The practical risk enhancement of negating this exception, this requirement, and all these statutory construction maxims, I think it's pretty clear that we aren't free to simply disregard what the legislature told us to look at.
But is negating the same thing as saying, hey, it's not applicable, it's not relevant?
No, I think what it's saying is they can't meet the standard that the legislature set. In any event, it's also important to note that they produce no evidence regarding the other three elements of this exception, and it was their burden to do so. The common law required, as I said, a fiduciary to prove to justify dealings with its beneficiary, and that's essentially what this statute does. The Supreme Court in the 7th District and multiple Ohio administrative decisions have said the burden of proof on this whole statute, this whole exception, is on the party invoking it. And there's they made no evidence or no arguments in the trial court as to why the other elements were present. They make the arguments in the brief now, but it's a little late to debut those things in the Court of Appeals. Those arguments.
Thank you,
should be
Attorney
moved up.
Marty. Unless there's any other questions from the panel? Thank you. Thank you
Thank
for
you.
your argument. Attorney Bruns?
Thank you. A couple things. I think when you hear things that aren't in the record and aren't proved, and yet they're asserted positively, it tells you something about the rest of the arguments. And you heard the state say that there's evidence in the record that employees, plural, were depositing their paychecks into Valerie Lee's account. That is simply not true. Her daughter, Nicole, had a shared account with her mother. That's why that paycheck got put in that account. You also heard counsel say that every case in Ohio that has looked at this issue has supported their position. That is a blatantly untrue statement. The only case, he cited the Johnson case. The Johnson case is a BMV case. The Johnson case is not a charter school case where there was an audit, no finding for recovery was made, and yet the Attorney General then later sued successfully under 117.42, which is.
Franz, let me ask you, he made the point that there were other bids submitted and that they were lower than Creed's. Is that accurate?
Yeah, I was getting to that, and the full factual record is that yes, that this was put out for competitive bid. Other bids were lower. None of them met the scope of services Seed proposed, and that is why the board, with independent counsel, awarded Seed the contract, because Seed provided more services for the amount it bid than any other bidder.
So where is the affirmative evidence? If you have the burden, and I know you dispute that, but if you have the burden, where's the affirmative evidence in this stipulated record to show that you satisfy all of the elements of C?
So Your Honor, we listed those in our brief, but at the end of the day, I would say this, I would go back to that burden of proof argument. State versus Knuckles, which we cite, it is crystal clear that an exception to liability in a criminal statute, in fact, requires that the burden of proof be on the party asserting it, the state, in terms of the statutory liability. It is not an affirmative defense, okay? And so that exception, C is an exception to liability, and State versus Knuckles says, if you want to show liability under that statutory cause of action, which is what the state did here, and it's the only basis ultimately of the trial court's finding of some illegality. If you are asserting that positively, then your job is to show the exception does not apply. So it was the state's burden of proof, and the state failed to meet that burden of proof on each and every element. In terms of I'll go back to it. In terms of 117.42, that is the sole basis of the state's standing authority. In this case, we got here because they have a letter from the auditor of state well after the fact saying sue under 117.42, okay? What you have not heard today is that they have that general broad authority under 117.42. Why did the legislature give them specific authority that specifically would apply in a case where they audited a charter school and then yet never made a finding for recovery? All that language in 117.28 and 117.30 is superfluous. And you've never heard an argument from the state as to why the legislature put that language in the statute. Finally, the argument that, oh, well, we get common law authority in a case like this, New Choices dispenses with that. There is no case in Ohio that says you can sue under common law or you can sue under strict liability or any of the theories that the Attorney General sued under where the public entity, the charter school, has been audited and no finding for recovery has been made.
Counsel, unless there's any other questions from the panel. Thank you both for your arguments this morning. We will take the matter under submission and issue you a timely decision. And we wish you both a wonderful